Hello friends, my name is Dr. Jigisha Singh, and in this video I am going to explain the concept of acceptance as provided under the Indian Contract Act. Well, along with the other important provisions of the Indian Contract Act, we would be focusing on the essential conditions for a valid acceptance. As far as the definition of the expression acceptance is concerned, it is provided under Section 2B of the Indian Contract Act 1872, which states that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. With this, we move on to the essential conditions for a valid acceptance. Number one, acceptance must be made by the acceptor or his duly authorized agent. Acceptance made by an unauthorized agent is always void. For example, A makes an offer to B. The same is received by the steno of the acceptor. He thinks the offer is beneficial for B and communicates the acceptance without taking any consent from B. Acceptance made by the steno is void. Next essential condition is the acceptance must be communicated by the acceptor or duly authorized agent. Offer should not only be accepted, it must also be communicated. It is a must that the communication of acceptance is done. Mere mental acceptance in the eyes of law is no acceptance. In addition, there must be some external manifestation of the acceptance, and such external manifestation is possible through communication. Section 2B expressly provides for that acceptance must be communicated. As a general rule for a binding contract, the acceptance must be communicated by the acceptor to the offerer. However, there are certain exceptions to it where communication is not required. Section 8 provides for acceptance by performing conditions or receiving consideration. The first exception is acceptance of consideration sent by the offerer along with the offer is a valid acceptance without communication. Example, A wants to purchase goods from B and makes a suitable offer. Along with offer, A sends a check of Rs 5,000 in advance payment and B gets the check and cash without communication of acceptance. The moment B gets the check and cash, there is a binding contract. Another instance would be A wants to get his life insured through life insurance policy of LIC. In consultation with the agent, A sends all the necessary documents and a check to serve as advance payments for first insurance premium. Before any communication, the check is credited in the account of LIC. A dies before communication. Here the legal representatives can claim the amount of policy as there was a binding contract the moment LIC, Life Insurance Corporation, got the check of A credited in their account. The next exception is performance of the conditions of the offer by the acceptor is a valid and a binding acceptance even without communication. For example, son of A is missing. He distributes pamphlets that whosoever traces and brings the child would be rewarded a sum of Rs 10,000. B, as a matter of coincidence, finds A's son and gets him to A. There is a binding contract between A and B as B has performed the condition of the offer. Therefore, acceptance is binding without communication. Another instance would be A, the owner of a plot allotted to him by DDA, sends to B a suitable offer that A can sell the plot only after obtaining prior permission by DDA. B accepts the offer by obtaining no objection certificate by DDA. Here no communication of such acceptance was made. Mere performance of condition is sufficed and is a valid acceptance. Next exception would be where the offerer impliedly or expressly dispensed with the communication of acceptance, that is, acceptance need not be communicated. For example, A makes a suitable offer of purchase of good to B and state that if B accepts the offer, he should dispatch the goods immediately. The next exception would be when both the parties have actually acted upon the terms and conditions of the contract without communication is a valid and binding acceptance without communication. For example, A used to supply coal to B, a railway company. There was an oral contract and there was some rise in the price of coal. A requested the company to revise the old prices here. He also advised the company that instead of oral contract, we should be having an agreement in writing. A suitably drafted the terms and conditions of the same send the same to the railway company. On receiving the agreement, the company did not communicate their acceptance of purchase of coal in the revised prices. After this agreement in writing, A continued to supply coal to the railway company and asked for the payment on the revised prices. Without communication, both parties acted on the terms and conditions of the new agreement. After some time, the company refused to make payment on the revised prices. It was held that there is a binding contract in spite of a general rule which says that acceptance must be communicated. In the given case, the communication was implied as both the parties performed or acted on the terms and conditions of the written agreement. It is a binding agreement. The next essential condition is communication of acceptance must be made in some usual and reasonable mode of communication. By usual, we mean commonly, normally adopted by public for making that particular offer. By reasonable mode, we mean mode whichever adopted is sufficient to make the communication effective and complete. When the offerer in the offer prescribes a particular mode of communication of acceptance, the same mode or method must be adopted. In UK, in such a case, if communication is made by a method other than the prescribed mode, is always void. However, in India, in such cases, if communication is made by a method other than the prescribed mode, is valid. But in such a case, the offerer can make it invalid if after the receipt of acceptance within a reasonable time, the offerer informs the acceptor that acceptance must be made by the mode prescribed. If the offerer does not say anything and remains silent, in such a case, the acceptance is deemed to be accepted by the offerer and thus it is valid. For example, O, the offerer prescribes that a communication of acceptance must be sent through a messenger, but A, the acceptor, sends the communication through speed post, which is an equally effective mode of communication. In India, such communication is valid until and unless the offerer makes the communication invalid by asking the acceptor to make the acceptance in the same mode prescribed. But if the offerer remains silent about the mode of communication, it is a valid acceptance. That is, the offer doesn't object to it within a reasonable time. This is also provided under Section 7, subsection 2. As a general rule, where the offer does not prescribe a particular mode of communication, it must be sent by a usual and reasonable mode of communication. Usual and reasonable mode depends on the facts and circumstances of the case. In case of gold, reasonable time would be a day. In case of a perishable good, it would be a week. The courts have decided that the mode by which the offer was communicated is ordinarily presumed to be usual and reasonable mode of communication. Therefore, the same ought to be adopted for the communication of the acceptance. For example, if the offer is sent through registered post by the offerer to the acceptor should send the acceptance through registered post. Such a principle is just a guideline and not any hard and fast rule. If the acceptor communicates the acceptance in the same mode in which the offer was communicated, the communication made by the acceptor is presumed to be usual and reasonable mode of communication. If mode adopted by the acceptor for communication of acceptance is different, then there is a possibility of proving that the said mode as usual or reasonable mode of communication by the acceptor. The next essential condition is offer must be accepted before it lapses or ceases to exist. Relevant section is section 6, revocation how made. There are 4 different methods by which an offer comes to an end. That is, offer lapses and acceptance is meaningless after the lapse of offer. The first possibility is by sending a notice of revocation to the acceptor, and the notice of revocation must reach the acceptor before the communication of acceptance is complete as against the offerer. The notice of revocation can be given orally or in writing. For example, A makes an offer to be communication of acceptance was made on 1st April 2026 at 10 a.m. Notice of revocation of offer must reach before or at 10 a.m. Letter of revocation prevails over the letter of acceptance. Letter of revocation after 10 a.m. is meaningless and acceptance would be binding. The next possibility is on the expiry of the period specified in the offer for its acceptance, where no period is specified on expiry of a reasonable period of time. In such a case, the letter of revocation must be sent by the offerer to the acceptor before the expiry of the period specified for acceptance, though the letter of revocation may reach the acceptor after the expiry of the period specified for acceptance. Example, suppose the period specified for acceptance expires on 1st April 2026. Letter of revocation must be sent by the offerer before 1st April 2026. However, it may be received afterwards. That makes no difference. The next possibility is the offer lapses on the failure of the acceptor to perform the conditions of the offer precedent to acceptance. For example, A makes an offer to B where he is willing to sell certain goods to B. An offer contains a condition that before acceptance he should be sent rupees 10,000 as advance payment. Without sending the check, the acceptor B communicates his acceptance. His acceptance is meaningless. His communication of acceptance is made without fulfilling the condition precedent to the acceptance has no meaning and offer lapses. The next possibility is the offer lapses on the death or insanity of the offerer, provided the fact the death or insanity comes to the knowledge of the acceptor before acceptance becomes complete for the offerer. The two conditions that needs to be fulfilled are fact of death or insanity of the offerer. One of the two events must be found. The acceptor must acquire the actual knowledge of death or insanity before communication is complete, as is the offer. Now, the acquiring of the knowledge of the fact of death or insanity may be from any source. Mere fact of death or insanity does not result in the lapse of the offer. Further essential condition is acceptance must be absolute and unqualified as given under Section 7 of the Indian Contract Act. Further, offerer cannot impose upon the acceptor the burden of communication of refusal, meaning thereby, for instance, the offerer make an offer to A through letter, and at the end of the letter writes that in case I do not hear anything from you by 30th August 2026, I shall assume that the offer is accepted by you. Till that date, suppose if A does not communicate, will it amount to acceptance? No. The answer is no. Any such condition in the eyes of law is meaningless. A is under no obligation to communicate refusal even if there is a condition given with regard to it. Such a condition is not binding on acceptor. Further, with this, I conclude the lecture. In the next video, I would be discussing about provisional acceptance and government contracts. Thank you.